Dear students, a very hearty good morning to all of you. And today we shall be seeing the concept of which we have started in the last class. People or the persons who are entitled to ask for a partition under the joint family. The students, we have started this concept, and prior to this concept, we have discussed the effect of the Amendment Act of 2005, by which a daughter now becomes a co-partner, and she shall also have the right to ask for partition. But as I told you, we are discussing the classical law and 2005 amendment. We are having the Hindu Succession Act, the rules of succession in the last module of a syllabus of Hindu law, in which we shall be discussing in detail. Okay, dear students, if you are able to recall the things, will I just give you a brush so that we are able to check the connections of the various things which we have seen. The very first person entitled for partition to ask for a partition is the father. And all, my dear students, the father is the person, we can say that he's having the right to ask for partition. Also, we have seen that the Takshara jurisdiction says that the father's right to partition is superior to the right to the right of partition of all others. The fathers cannot only effect a partition between himself and his sons, but he can also impose a partition on his sons, which is subjected to certain limitations. But the Dayabhaga school of law says that the father is having the absolute power of on all properties, and the question of partition during his lifetime does not arise, though he can, if likes, distribute his property among his sons. So, dear students, there is a difference between Mutakshara and Dayabhaga. The difference which we are appreciating, discussing from the, we can say, beginning. And also, dear students, we have seen that how the father has to act bona fide, and he has to follow or observe the principles of equity, and he should not treat others unequal or act fraudulent or vitiate the favoritism. The partition can be reopened. So these are the basic elements of the father, who is also, we can say, the head of the family and also entitled. So in our list, the father is number one. Then, dear students, we have seen a few case laws by which we try to realize the position of father, and also we have seen the son, grandson, and great grandson, as they have a right to partition in the Mutakshara school. But when we talk about the Bombay school, there also the son has no right to partition. There are certain differences which I have tried to highlight. Also, dear students, we have seen that how the Dayabhaga school is having its impact on the sub schools of Mutakshara law, and how these differences are there. Dear students, we have seen in detail, not going into detail, but the only purpose, the only intention of mine is to connect the things, so that, because every concept or topic is interrelated, and there is a high probability that you may forget something, and only the crucial things I want to highlight and make fresh in your memory, so that when you proceed further, it becomes easy for you to connect the dots. My dear students, we have also seen that how Punjab customary law is having a bend, and how it is talking about regarding the no partition, no right to partition against the father. These are the basic differences which we have seen and we have discussed. Also, we have tried to analyze the rulings and the findings of the Honorable Court, by which the Honorable Court has tried to lay down certain guidelines, by which the Honorable Court has tried to give us certain instruction in the case of son and great grandson, how these particular laws should be interpreted, how these laws are to be followed. Then we have seen son born after partition, and here also there were a difference, or rather we can say a sort of a conflict of view with the we can say with jurists, the scholars, uh, Vishnu, Yaj Navalka, and then further we have seen Gautama, Manu, Narada, Brihaspati. These are the scholars who are having different connotation, or they have defined the right of the son born after partition. And there are certain, we can say, formulation or certain sort of modification or certain sort of an agreement which has been reached by the Mitakshara school. So this was the last, we can say, concept which we have discussed with the help of few case laws. Now we have to see, we have to start son conceived at the time of partition but born after partition. When we check this particular concept, when we discuss this particular concept, we find that the Hindu law has, for many purposes, equated person in the womb to a person in existence. Okay, there are certain instances by which the Hindu law has tried to equate it, the born child in the womb as a person who is already born, because there are certain presumptions which law makes, there are certain, we can say, premises which the law draws, and it does only for the convenience, or for it, we can say, for justice. Okay, these are the we can say purposes why law many a times draw certain uh, uh, conclusions or have certain presumptions. So the text says that if a pregnancy is known, and if there is a pregnancy which is known that particular woman is pregnant, she is expecting a child, the partition should be postponed till the child is born. This is a, we can say, common or simple rule according to which it is held that the partition should be postponed the date the child is born. But if the co-partners do not agree to this, then a share equal, we can say, to the share of a son should be reserved for the child in the womb. Because somewhere Mitakshara school also talks about the birthright, and the same exists here. We talk about the, when we appreciate the Mitakshara school, and its impact is also, we can say, is wider as compared to the other schools. And therefore, the son is having the right, and it is being assumed that the moment the child is conceived, so a question may come that that particular point of time there were no, the science was not so developed. How we can know whether the child is male or female? So that is also, we can say, something which used to work on assumptions or presumptions. And if the child is born, then he used to get a share. So we can say that if the child is born a son, he takes it. But if it is born a female, as I told you, a marriage provision used to be made for her out of the share reserved in the surplus. So this was the common practice, that if a child is born and it was expected that it would be a male child, but when a female was used to take birth, so what used to happen? So a certain amount for marriage provision was reserved from the share, and the surplus, if any was there, it was further distributed among the co-partners. So there is only one case which is, we can say, an old case in which there was certain, we can say, a particular rule was discussed. The name of the case is in front of the screen. Yaka Yamene Yame versus Agni Sore. In this particular case, it was held that in case no share is reserved for the son in the womb, he can, after his birth, demand reopening of the partition. So, if by default or by, we can say, intentionally, uh, the co-partners get no share for the son born, or the son who was in the womb. So, after his birth, he attains the age of majority or his guardian parent to be born. He can also demand for the reopening of the partition. Okay, so it is said that if the pregnancy is not known and consequently no share is reserved, then also the redistribution of the state should take place. And after the birth of the son, we can say, in other words, in a case also, after born son can get partition reopened. And this rule apply to only to the, we can say, partition between fathers and sons. So, he is a particular individual who is having a share in the in his, we can say, co-pastory, and therefore it is a duty of the father according to the law, and therefore the rule applies to the partition between the father and the sons. So this is the common practice and common, we can say, notation about the son conceived at the time of partition but born after partition. So he's having full right. He can go for a reopening of partition. He can claim for it. He can ask for it. But this rule is limited, we can say, between the partition which happens between the father and the son. Okay. Now we have to see today another topic, which is son begotten, which it was and born after partition. So when we talk about the son begotten and born after partition, in this case, we find that the Mitaksha school in general applies the rules, and because of the rules of Mitakshara, there are two situations which arises, which may arise, or we can say. The very first is that when the father has taken his share in a partition, in a condition where Mr. Father has taken his share, now what will be the impact? What will be the consequence when the father has already taken his share? Whether the son is in a position to claim from the whole family, or it is only the liability of the father. This is the question in the first condition. And second condition may arise that when the father has not taken any share. So there are two special conditions when in the case the Mutakshara's general rule applies. The very first, as I told you, discussed, means the father has taken the share, and second, when the father has not taken the share. So in the condition, we can say that when the father has taken or reserved a share, okay, when the father has taken or reserved a share for himself, the after-born sons become a co-partner with his father. Okay, so now he, as I told you, that he is attached to the father's property. He is having, we can say, a share in his co-partner. And this particular concept has been further discussed in the case of Kalidas versus Krishnan, which you are able to see in front of your screen. And dear students, in this case, it was discussed that after the death of the father, he takes not only his estate but, by survivorship, okay, but also he also inherits the entire separate property of his father, okay, to the exclusion of divided sons. So divided sons are excluded, but he is attached to the father. So he is having the right, son begotten and born after partition. And in the case when the father has taken the share or has reserved anything for himself, so what happened in such cases? He is having the right, and he is a claimant, In the condition the father dies, and after the death of the father, he takes his share, not only by the survivorship, because we know what are the rules of survivorship, which we have discussed in the very, we can say, early classes, and how the survivorship happens and what is how this concept of survivorship has given birth to the concept of notional partition and all those things which we have discussed. The same things are reflected here again, because in this particular second part of the family law, we are generally, if you are able to analyze behind, if you are able to read between the lines, you will find that we are somewhere dealing with the concept of property as as a whole. In the first family law, we can say, which you have studied in your second semester, in that particular, we can say, semester, you people have gone through only the concept of marriages and divorce and certain things which are related with it. But this semester, you are basically concerned with, we are basically concerned with the notion of property and the issues of property, the legal assets which are there. The whole concept of, we can say, of semester 3 of family law is revolving around this particular notion itself. So if the basic is clear to you regarding the things which we have studied in the very the foundation lectures of our, we can say, of the semester, it will be very clear to you that how the things are interconnected, as I told you, how the things are having their own universe, and the concept of alienation, adaptation, partition, the succession, inheritance, all are revolving around the same, we can say, are having the same sun, same, we can say, focal point, and they are revolving around, we can say, in a sort of a orbit, which is having the same, we can say, common point. So this is what we can say we are doing in this particular semester. Okay. But now what happened after the Hindu Succession Act, as I told you, there are two parts. Whenever we are studying or reading, we have to understand that now what is the condition after the codification of Hindu law, and what was the condition prior to codification of Hindu law. This should be very clear in your mind. Time and again, I told you that we are appreciating a classical law. We are appreciating the evolution, the development, and we are also analyzing, or we are also seeing the growth of Hindu law. So it may be segregated into past, post-independence, and pre-independence. Post-independence codification came, and then after, in the year 2005 also, it is a very major year, with we can say, with the females getting the right for partition also. So it would be easy for us to understand that now what is the position. We have seen that if suppose the father has taken a share, the son has what needs to get a share from his father, because he becomes a co-pastor. The son needs to become a co-pastor, and we can say he was having the power of survivorship, and also he needs to inherit the entire separate property. But now, after the Hindu Succession Act 1956, the condition, the rules, we can say that has been abrogated, because as Section 8 of the Act makes no distinction between the separated sons and undivided sons. So further, the rule was there that the son used to inherit the entire separate property of the father to the exclusion of the divided sons. But after the Hindu Succession Act came, this particular rule, because of Section 8 of the Hindu Succession Act 1956, makes now no differentiation, no distinction, and between the separated and the undivided son in the matter of succession. So to the separate property of the Mitakshara Hindu. So this is now, we can say, this is the new development which came, and because of this, the rule which used to be appreciated, the rule which was standing, has been abrogated, and now the concept of the exclusion of divided sons is no more. So this is the practice whenever we are dealing with this particular family law, because family law is having its own premises, and if you are able to understand that particular premises and what is the evolution and what is the effect of codification, then it becomes that it makes your work quite easy to understand and grasp the concept. Now we have to see that what will be the position, the very first condition which we have seen where the father has taken his share in a partition. And in a situation when the father has not taken any share, now the father has not taken any share, what would be the condition? And this particular thing has been discussed by the Madras High Court, the earlier case, Ch- Ch- Chenagama versus Munisami. This is the case. And it was held that when the father has not taken or reserved the share for himself, the afterborn son has a right to get the partition reopened and get the estate redistributed as it then stood. Okay, so you can say that this rule is quite, we can say, is having its own, it's giving the power right to this to the born child, that the afterborn child has been given the power or right to get the partition reopened and get the state redistributed as it then stood. So when the father has not taken any reserve or share, and now this particular child who is been born has been denied or was not given, so he's having the full right to ask for this particular thing. So again, this rule applies the former to a partition between fathers and son. Okay, this is also something very similar. If you are able to note it, that the rule applies like the former which we have seen just now to a partition between fathers and sons. It is the son who is attached or related to the father. So he is having, we can say he is following his father, and therefore he is a shadow of his father, and no more. He can't say that he's having another, we can say, uncle and whatever. No, he's his shadow. The same thing again has we discussed when we talk about the co-pastory, and we talk about the condition when, you can say, a person was born. And there was a particular case in which the facts have been discussed. The case of Kusum versus Gasarthi, the Calcutta High Court has pronounced it. Also, the same, we can say, case, or rather the same rule have been discussed in the case of Shivaji versus Vasant Rao, and it was discussed by the Bombay High Court in the year 1990. So suppose a co-pastoree was there, and in this particular case it was there, which used to consist of a father which was named A, and he used to have two sons B and C. So father A, two sons B and C. Then what happened? Partition take place. Subsequent to partition, which means after the partition, another son D was born to A. Now A is having three sons: A, B, C, D. Sorry, B, C, D. Three sons, and a son B is born to B. Now father has, after partition, a son was born to father Mr. A, which was named Mr. D. Now the first son B also has a child for Mr. B. A child is born, male child, whose name was BS. If A has not taken the share, then what will happen? His born son, a child born subsequent to partition, named D. D can get the partition reopened, but BS, who is a child of B, he is having no such right. We able to get it. So what happened? Only the son is having the right, and not a grandson is having this particular right. So these are the rules, and we have to, what we can say, appreciate the rule as they are coming, not in a position. And another situation may arise. So I'm discussing you one by one different situations. The very first which we have seen that where the son has been born to the partition after. and the father has not taken any share for himself, and the afterborn son has a right to get the partition reopened and get the estate redistributed as it then stood. And further, we have seen that the rule applies in the former, and we have seen that the partition between father and son. Also, we have discussed that the grandson is not having the right, because we are talking about the concept of son begotten and born after partition. So another situation may arise that when a co-partner renounces his interest in the joint family. There was a co-partner who renounces his, you can say, his interest. The question is, has a son conceived and born to him after he has renounced his interest? The question which the court will ask, or the court will seek, whether a son has been conceived or born to him after he has renounced his interest in the joint family, and therefore any right or interest in the joint family property, and can he claim a share if partition take place? This is a situation which we have seen, by which a particular person may alienate the property of a particular person. We have seen this particular concept. We have discussed this particular concept when we see the alienations and all those things. Okay, so there also we have seen the same thing. And in this particular situation, if suppose some co-partner has renounced his interest, he has left his interest, he has ceased to be a co-partner as a particular in the eyes of law, which says that in regard to the share. And when a co-partner renounces his interest in the joint family, the question is, has a son conceived and born to him after he has renounced the interest in the joint family, to state any right or interest in the joint family property? And can he claim a share if the partition take place? So, in the case of Anjan Yulu versus Ramaiya, in the year 1965, the full bench of Andhra Pradesh High Court considered the question and observed that on relinquishment of his interest, the co-partner can no longer be regarded as a member of the co-partner. The co-partner leaves the interest. This particular co-partner can no longer be regarded as a member of the co-partner, and therefore a son begotten after his revocation, he cannot claim the status of the co-partner. He is having no right to ask for a right for the status of a co-partner, because his father has already renounced his interest, and we know that somewhere the son is a shadow of the father. Shadow means whatever is falling, rights or liabilities of shares, that is passed to the son. Okay. So this is the status. And therefore a son begotten after his revocation cannot claim the status of a co-partner with the remaining members of the undivided family. And Justice Reddy said that he could be a co-partner with his father. He could be a co-partner with his father, but he could not be added to the original co-partner, because necessary nexus of this, which is, we can say, the membership of his father in the original joint family, is absent. So everything depends upon the father, and the concept which we are trying to realize is that son begotten and born after partition. So in this classical case, son begotten and born after partition, everything depends or revolves around the interest of father, the share of father, and whatever the father is taken or is to have, that was something which was passed to the son. This is the concept which we have discussed in the second topic of our son begotten after partition. This one. Okay. So there are two concepts in this, we can say, PPT in this slide of ours. Son conceived at the time of partition but born after partition, and son begotten and born after partition. So these are the two cases which we can say. Okay. So both the situations are different. Here it is talking about that the time of partition he was there in the womb of the mother, but was born. Here it is saying that the son has apparently born after the partition. That means that during the partition also the son was not conceived in the womb of the mother. So dear students, this is what we have seen today. Okay. Now moving further to the next slide. Now we have to see, we are checking the what we can call the adopted sons. Although this concept we have discussed under the term of adoption, but still we have to check it, we have to see it, because somewhere it is the part of our, you can say, a syllabus, and the adopted son has also been given the right. The adopted son is also have the right to a partition, and whether he's entitled to for a share or not. What is the law on this particular section? Because the law is very rigid when it says that no outsider can come. It is a birthright and so and so and so. And the same thing has been dealt under the Dharam Shastra. We talk about the Dharam Shastra. The Dharam Shastra has dealt with the position of an adopted son with two situations are there. Number one, when there is a subsequent born natural son. Adopted son was there. Now, after adoption, a natural son is born. The father. And where there is no such son. So, when there is no such son, the text lays down that his position is the same as the natural born son. Two conditions are there. The very first, when we can say subsequent to a natural born son, adoption was there and the son was born, a natural born son, it may happen. And then if there is no such son, what will happen? So, if there is no such son, the adopted son would have the position same as that of the natural son. And he will have the right of partition. He is entitled to the share, and we can say that same right of partition, and he is not entitled to the same share. But in the case where a natural born son is born, he has the right of partition, but he is not entitled to the same share. So valid adoption entitles a male child to become a member. This we know. He's someone who is entitled, or he's a person. He also has a right to partition and equal share as well. And in their Bhaga law, an adopted son is compared to the born after born natural son. He takes one share, one third share in Bombay and Madras, and 1/5 share in Banaras, 1/4 of the share of the latter. The law relating to adoption has been now modified again. This was the old practice. The passing of into adoption maintenance act. It has been clearly laid down that the act there is no difference between the right of a natural born, legitimate son, and an adopted son. He can only demand partition, but also have the equal share to that of natural son of his adopted father. Okay, so position changes, and as the Dharam Shastra have divided two classical conditions, there is subsequently born natural son, the father, and there is no such son. So when there is no such son, the natural born son, the adopted son used to have the same rights as a natural born son. But if it's the same right of partition and was entitled to the same share as of a natural born son. But the right to partition, he is not entitled to the same share. So in competition with the subsequent born son, earlier, right now you are having the whole concept in front of you that how the Hindu Adoption Act has changed the position. But as I told, we are trying to discuss the classical law. So the subsequent born natural son takes a lesser share which differs from school to school. The Sudras accept in Bombay that he is entitled only to 1/5 of the whole share, whole estate, and in Banaras school, 1/4 of the estate. So these are the pretty things which you should remember that there are schools which differs with the subsequent, which differs in the share of an adopted son. In some school, per se, the among the Sudras, except in Bombay, where he's entitled to one-fifth of the whole estate, and in Banaras of the state, he shares equally after born Asura son. So among the first three classes, the position is under. In Bengal, he takes one third of the share, what of the state. In Banaras, he takes one fourth of the state, and further we can say in Bombay and Madras, he takes one fifth of the state. So this is the classical law which I am trying to discuss with you. But after the Hindu Adoption Maintenance Act, situations have changed. Okay, and also there were different schools and they used to play differently because each school used to have its what we can say its own interest, its own bent of mind, and that used to create a result. So in the case there is a case. The name of the case is called Guru Amma versus Malappa. In this particular case of Guru Amma versus Malappa, the position is something like that the sum of the High Court have been restricted interpretation to the afford proposition, and it is again a case of 1964, Guru Amma versus Malappa, and it was held that many of the High Courts have given a restricted interpretation to the aforesaid proposition of holding the adopted son is entitled to one third or one fourth of what Asura's son takes. The Hindu Adoption and Maintenance Act has now codified and reformed the Hindu law of adoption. In Section 12, if you are able to recall, very crucial under the Hindu Adoption Act, lays down that an adopted child shall be deemed to be a child of his or her adopted father or mother for all purposes. Section 12 is very crucial of Hindu Adoption Act because Section 12 reads that an adopted child shall be deemed to the child of his or her adopted father or mother for all purposes. And therefore, it is submitted that a provision could be marshaled to establish equality between the adopted son and the natural born son in partition also. So we have seen that how the laws have changed or the laws have modified, and now how the law has been interpreted, and we can say how the laws have tried to create equality which earlier was missing, because law also takes a look to the, you can say, the notion that the adopted son, the law is having a concern that the justice won't be given to the adopted son because it happens because real blood, as it said that real blood is count. People feel pain and we can say uh, have certain sort of emotions and certain sort of connections. But an adopted son, as he is coming from outside the family, there is a high probability that he won't be allowed or given certain things. So this was the case of Guru Amma versus Malappa. And another case which I would like to discuss with you is Rasala versus Rasala. And in this case, the situation is quite different. Here we have to see the son of void marriage. What will be the position of a son who is born to the void marriage or annulled marriage? Okay. So there was a case known as Rasala from Andhra Pradesh. This case was there. And it was held that the son of a void marriage or annulled marriage, voidable marriage, is not a co-partner. he cannot sue for the partition. Okay, and the contrary view is not correct. So we are just trying to discuss the things as they are. They're trying to appreciate the things. So what I suppose that today I would like to end up here because I have to again start the illegitimate son. And illegitimate son is a big and huge topic. And I suppose that I won't be able to justify it in 5 to 7 or 10 minutes, whatever, because it is having quite, we can say, there are a number of conditions which are attached to it, and therefore I would like to start it in a fresh class. Okay, so this is for today, and I hope that you people are able to connect the things as they should be. So take precautions. Have a nice day, and I would like to thank you all for your patient listening. Thank you.